going to look at a scenario today that is, well, it's pretty much a creditor's worst nightmare. Imagine you lend a lot of money, in this case it was 21 lakhs, to the partners of a firm. They give you a check for repayment, and it bounces.
The classic situation.
So you do everything right, you send the legal notices, you file the complaint, and then you get to the high court and they just throw your case out.
Right. Not because the debt wasn't real, but because of a tiny mistake in who you named on the legal papers.
Exactly. The creditor sued the partners who signed the check, but forgot to write the name of the partnership firm itself as a separate accused.
And that's usually been a fatal mistake. But that's why we're doing this deep dive into the 2025 Supreme Court judgment in the Davinder Prabhu v. Chandrasekhar.
It really is a rescue mission, isn't it? The court steps in to stop people from losing their money on a technicality.
It is. It all came down to how the lower courts were fundamentally misunderstanding what a business really is.
So let's get into that. Why would a high court dismiss a case when the actual people who signed the bad check were standing right there?
Well, the high court was applying logic from a very, very famous precedent, the Anita Hada case from 2012.
Oh, Anita Hada. Right. Every commercial lawyer knows that one. That's about companies.
Exactly. It's about companies. And that case established that if a company commits an offense, you have to name the company as an accused before you can go after its directors.
It's that principle of vicarious liability. The directors are only liable because the company is. You can't sue the employee without suing the employer, so to speak.
Precisely. And the high court just took that logic and pasted it directly onto a partnership firm. They said, since the firm wasn't listed, the case against the partners had to fail.
Which seems logical on the surface, I guess, but that's where the Supreme Court stepped in with a major aha moment, wasn't it? How did they fix this?
They went back to basics. They drew a bright, clear line between what a company is, what a partnership is, and legally, they're completely different animals.
So a company is what, a juristic person?
Yes, that's the legal term. It has its own legal soul, an existence that's totally separate from the people who run it.
But a partnership doesn't have that.
Not at all. A partnership is what the law calls a compendious name.
A compendious name. That's a great phrase. It basically just means it's a collective label, a shorthand for the people involved.
That's all it is. It's just a convenient way to refer to the group of partners. It has no separate existence, no soul of its own, the partners of the firm.
And that changes everything for liability. We're not talking about vicarious liability anymore.
No, we're talking about something much more direct. Joint and several liability.
Meaning, if one partner acts, they all act.
Yes. If the partners committed the offense, the firm committed it. They are one and the same. And because of that, the Supreme Court ruled that a legal notice sent to the partners is a valid notice to the firm.
You don't need a separate piece of paper for a name on a sign when the actual humans behind it have already been served.
You've got it. That simple distinction saved the entire case for the lender.
But what about the procedural issue? The fact that the firm wasn't named in the first place. Did he have to start all over?
No, and this is the other big win. The court said this is a curable defect.
So fixable.
Fixable. It's not a fatal error that kills the complaint from the start.
Yeah.
The creditor can just amend the paperwork to add the firm's name. It's about getting to the real justice of the case, not getting stuck in a procedural trap.
The message to lawyers seems pretty clear then. Stop applying company law like Anita Hada to partnership disputes. They're not the same.
That's the takeaway. You can't hide behind a corporate veil when, in a partnership, there is no veil to begin with.
It's definitely a good outcome for creditors. But, here's a final thought to leave you with.
Yeah.
The court is being very pragmatic here, blurring the line between the entity and the individuals to make sure a debt gets paid. If we keep pushing in that direction, does it risk opening the door for more personal liability in other areas of business law, too?
It's a great question. It certainly makes it harder for partners to argue that their business and personal affairs are totally separate.
Something for everyone to keep an eye on. That's all for this deep dive into Davinder Prabhu v. Chandrasekhar. Thanks for listening.